Welcome to this webinar and workshop on Beyond Ideas, Importance of IPR Strategies for Startups and MSMEs Growth. On behalf of ASSOCHAM and particularly the ASSOCHAM IPR Council, I welcome you. I am Dr. Himang Shah. I am also the India Engineering Lead for Qualcomm Technology Licensing. In today's session, we will discuss the importance and the aspects of IPR strategies, and we are joined by two wonderful speakers. Mr. Santosh Kumar Gupta, who is an Assistant Controller of Patents and Designs at the Patent Office in Delhi. And we're also joined by Ms. Pragati Agarwal. She is a Registered Patent Agent, RTTP, at ITTO, which is at the Indian Institute of Technology, New Delhi. Now, I will introduce them later on and give you a brief background about who they are and the amazing work that they have done. But today's webinar is also brought to you by L2 Pro. It is an IP e-learning program meant specifically for startups and MSMEs. So if you allow me, I will share my screen. Santoshi, by the way, I just can't see you now, so maybe things have changed in the backend. So L2 Pro is a program that is brought to you by DPIIT and CPAM, along with NLU Delhi and Qualcomm. And just for context, I have been working, through Qualcomm, working with startups in India since the year 2015 timeframe. And when we started interacting with the startups, we used to do a lot of workshops with them. And we've also, over the years, incubated 101 startups and mentored another 38 more startups. And these startups have collectively filed for more than 450 plus patents in India. And I'm happy to share that close to about half of them have already been granted, thanks to the wonderful SIPP schemes that have been brought to us by the IP India offices. And what it also tells you is firstly the awareness of IPR is increasing in the country. However, there is a lot more work to be done. If we look at the number of startups in India right now, if you visit the Startup India homepage, you will see 118,000 plus startups that are already registered at DPIIT. I guess people are having trouble hearing me. Let me just put on my headset. And hopefully I'm better audible now. Maybe if someone can just type in the chat box, that way I know.
Yeah, much better. Thank you.
Okay. Thank you. So if you look at the number of startups in India right now, we are at a lakh 18,000 plus registered startups on IPR. In India across various sectors. And why does a startup get started in the first place? It's because the founders and the CTOs have spotted an opportunity where they're like, hey, we got to make a meaningful difference to a product, or they've spotted a problem which has not been solved today. So the fundamental basis of starting a company like that is innovation. And if a startup scales well, if they are proving more market traction, then it is going to attract other players, and hence IPR becomes even more important for a startup. So we developed this program. It's completely free for everyone. You can visit it on the website, as you can see on the screen, l2proindia.com, or you can take it on any app store, where this program will help you better understand the value of IPR, how you can protect your innovations with patents, how you can use copyrights, how trademarks play an important role, how you bring IP considerations into your business model, and ultimately how you can bring your innovations quickly to the market. The course is split across 3 modules: basic, intermediate, and advanced. In my opinion, anyone, regardless of whether you are working in a startup or not, you should go through the basic module, because it brings you up to speed with the most important IP rights. Then you can go dive deeper. You can understand what happens really behind the scenes, how your patents are evaluated, for example, or if you're growing your team size, what kind of agreements you got to have, both with your future employees as well as with, let's say, investors and other companies you will be interacting with. And finally, the advanced level, you get further nuances as to what funding is, how VC works for IP for startups, how standards work, and how disputes and how you can go about disputes should you ever encounter that situation. At the end of each level, there is an assessment which is based on a case study. And see, the idea is not to make you just fully up to speed with the theory of what IPR is. It is to make you a practitioner. So the case study will go like, hey, here's a situation a startup is encountering. What will you do? So in the basic level, there's a case study which talks about a company which is making an innovative pen, and they're planning various features into it. They want to launch it in different countries. What should the strategy of this company be? And you will encounter such a situation as we have seen with startups, that we have interacted with. We also want to make this material to be fun and more like a reference guide. So, for example, there's a screenshot where you're seeing where you can find the patent and trademark facilitators on the IP in your website. You have pop-up questions, which will, make it a bit more interactive. Make no mistake, we are the TikTok generation, right? We like to watch reels, everything. Time is limited. So for every lesson, you have a 2-minute intro video and a 2-minute summary video. So you give 5 minutes and you've understood about 60 to 70% of the course, and the rest of the material you can go at your own pace. The best part is at each level, if you pass the assessment successfully, you get a certificate which is provided to you by DPIIT, by CPAM, by NLU Delhi and Qualcomm, and this certificate is also provided to you at no charge. I'm happy to share that more than 7,000 learners have already taken L2 Pro, and I invite you to be a part of this program. In the chat box, you will see links that that you can directly take action on right away. And with this, let me pause here. And now I invite Dr. Santosh Gupta to share his insights with us. But before I do that, please allow me to give you a brief background about Mr. Gupta. Mr. Santosh Gupta is an engineer turned quasi-judicial authority. He is an assistant controller of patents and designs in the Patent Office, Delhi, under the DPIIT Ministry of Commerce in the Government of India. He holds academic degrees in the fields of information technology, software systems, and IP rights laws. He also holds a diploma in fostering innovation and commercialization of IPR from the Copenhagen Business School, Denmark, and has been certified as an innovation manager by Dansert, which is a part of the Danish Technological Institute. Mr. Gupta started his career with the corporate sector by working in one of the Microsoft Centers of Excellence before he switched over to the public sector as an IT expert. And prior to joining the patent office, he has worked as a scientist in one of the bodies of the Ministry of Electronics and Information Technology, which is MeitY, again in the Government of India. Mr. Gupta has been working with the patent office for about 10 years and has dealt with a very impressive 3,000 plus patent applications in the field of computer science and ICT. He has been instrumental in the formulation of several procedural guidelines, such as the Guidelines of Examination of Computer-Related Inventions, or CRIs, the Manual of Patent Office Practice and Procedure, MPOPP, and the Guidelines for the Patent Prosecution Highway, the PPH. He has also functioned as a faculty at the Rajiv Gandhi National Institute of IP Management, RGNIIPM, Nagpur, for the various batches of newly recruited Group A officers of Government of India and for public training programs in the field of IPR. He has published several scholarly articles on IPRs and disruptive technologies like blockchain. Santoshji, thank you so much for joining us, and we look forward to hearing from
you. Thanks a lot for this kind introduction, and and thank you so much for this invitation to this particular talk, which is with regard to beyond the ideas. So whenever we talk about something which is beyond the ideas, it always goes that when we talk about beyond ideas, what should be our focus? And first focus that comes to our mind is that commercialization of those ideas, because that is where, as Indians, we have been lacking. In India, we have brilliant ideas, but we fail to commercialize it properly. So, what are those technologies, techniques? Like Dr. Shah was talking about various things, and the number of startups that we are having. We are one of the, you can say, best ecosystems for the startups. But whether that various ideas, frugal innovations, that is our forte, that is getting converted into the commercialization success, that is where the focus should be. That how we can enhance the profitability and the commercialization aspect and extract maximum out of the ideas that we have. When we talk about intellectual property, it is. Am I audible to everyone?
Yes, sir.
Yes, sir, please.
Yes, yes.
Okay. Great. I thought that whether there is some issue with regard to the audio. So when we talk about intellectual properties, first thing that we'll have to understand that it's not just an academic aspect. Intellectual property is something which has got a commercial value like all the properties that we have. And instantly, when among all the esteemed listeners and all the attendees, if I ask that what are the properties that you are having, everyone will talk about the various physical properties and the tangible properties that they are having. They'll be talking about their cars, their house, and a lot of other properties that they have. But in the process, we fail to recognize the intellectual aspect, the intellectual property, the intangible things that we have. In the process, this particular aspect, which is a creation of a human intellect, commercial aspect of that somewhere gets denigrated, or that gets second class citizen. And that is what we should think about, that we need to bring ourselves out of this shell. And that is where the IP and the IPR are going to help us. Sometimes we have brilliant ideas, sometimes we create various IPs, but whether we get R attached to that, R means rights. We all have intellect, we all have intellectual properties, but whether intellectual properties are getting assigned rights to make it IPRs, intellectual property rights, that is where this commercialization aspect and potential to be commercially success lies. This linkage needs to be achieved, and that is what today's talk will primarily be around. That what are different things that we have in IPR. So I'll share my presentation and just confirm me that it is working fine. So let me. So is my screen visible to everyone?
Yes.
Yeah, one more confirmation, please. Whether it is moving.
Yeah, all good.
Oh, that's great. So this is what today's talk about. When we talk about, so when we talk about the importance of IPR strategies for startups and MSMEs, so first thing we need to understand that when we talk about IPR, when we talk about IPs, these two things are different. Many a time we get confused with IP with IPR. So basic thing is that when we talk about IPs, it is basically the creation of human intellect. So ideas and the expressions that is there of the which is arising out of human intellect, and it should have commercial value, because when we attach the word property to something, then it means that it should have certain commercial value, and it acts as an asset which can be, of course, bought, sold, mortgaged, licensed, exchange, and all the other forms. Why this IPR is important? this particularly this IP and attaching rights to this. You just imagine a situation where I can say that I came up with a beautiful idea to solve, say, one of the biggest problem that we encounter almost every winter in Delhi is bad air quality. So say I can while I am sitting in my office, some some fine day I come up with certain brilliant idea that okay, this should be a technology which can purify the air of say Delhi. Now I have got this idea, right? I start working on that, and I start coming up with certain solution to that. At the same time, there is someone who also comes up with that idea. I'm working in my own world in silos without disclosing anyone, and I'm very happy that I have come up with a brilliant idea. And this particular idea will have a lot of commercial success. This is my perception. I'm not doing anything other than developing that technology. While the other person, while he or she is developing that particular technology, that person also looks into the other aspect that there should be certain ownership that should be attached to that particular knowledge. That there should be some mechanism which should say that I'm the person who has this knowledge and who invented this knowledge or who was the first creator of this particular knowledge. So see the scenario, there are two people, one person who is just focusing on the work, the intellectual aspect, but not thinking about the commercialization and ownership of that knowledge, while there is some other person who is also thinking about the ownership and getting his or her name attached to that particular knowledge. So when we talk about that other person, that say few years down the line, the other person will be in a better position to establish that this is my right. Tomorrow, say that technology becomes very successful and someone tries to copy that, the first person will not be able to do anything. In fact, first person is liable to be sued by the second person, because second person is the one who has got this ownership of that particular knowledge. So that is why just working and creating knowledge and ideas and expressions, that is not just important. We must think beyond that. We must think about the ownership of that knowledge. So choice is ours, whether we are thinking about prospering with that knowledge, utilizing the ownership of that knowledge and prospering, or tomorrow we may fall victim to be known as the knowledge piracy. Since I have not attached my uh, ownership to the knowledge, someone else has got attached. So that person can sue me. That person can say that I'm using his or her knowledge. So that is why the importance of knowledge or having an ownership attached with your knowledge is. And here, that is exactly the point where IPR plays a decisive role. So when we talk about that beyond ideas, what is the importance of IPR? And then we'll talk about what are various strategies for the startups and MSMEs. This is first thing, because startups and MSMEs, when they start, the issue is that they have got limited capital, they have got limited resources. So most of the focus is with regard to creating new ideas, building new products. But in the meantime, they forget to attach their ownership with that particular knowledge of that particular product. So tomorrow, when some dispute arises, that is where uh, various MSMEs and startups find themselves at the wrong foot, and which is the purpose to actually appreciate the importance of IPR and various strategies that is there. So first thing is that understanding properly that what is IP. So IP is intellectual property which gets created by the human intellect and which has most importantly a commercial value. Then when we talk about importance of ideas and the innovation, so of course innovation plays a vital role for the economic growth. It solves various problems and it is of huge utility to the user. It at large benefits to the society. Many a time people will talk about that IPRs are monopolies, and there is a notion that IPRs may not be working as they may not be as beneficial to the society as it is presumed to be. But it stops a very important phenomena, which is it stops reinventing the wheel phenomena. When someone invents something and someone puts it in the public domain by getting an IPR or say patent to that, so other persons are free to utilize it from there. So at large, it benefits to the society. Then it helps innovation, because once you invest something, you get a right, and thereby you get a monopoly that you can exclude others from utilizing that technology without your permission, without your knowledge, without your licensing, or without paying any royalty to you. So you exclude those people. This gives you a tool to commercialize or to commercially exploit your knowledge or your rights. And since you are investing something, you are getting a right, and then you are putting that utilizing that right to for your commercial success, then you use that commercial success for further innovations, and this way a virtuous cycle get created in the society. So this is how the IPR system helps innovation. And when we talk about IP system and the developments, so basically that, of course, you put certain expenditure for the R&Ds. In inventions come, then you get patent over that. You do technological development, which helps in growth in the GDP, which leads to economical advancement, and then further enhanced expenditure in the R&D. And this whole virtuous cycle leads to something called sustainable development. Developments are there, but our modern day focus is more on the sustainable development. Whether financially it is sustainable, whether environmentally it is sustainable, or logistically it is sustainable. So it helps in those aspects. So now when we talk about, so first thing that I talked about is what is the intellectual property when it gets created. When some idea is coming, that idea gets created in, say, in someone's mind, then that person uh, tries to utilize those ideas, and works on, does certain further research on that, and with that further research that person comes up with certain rights, certain means certain intellectual property that gets created. This intellectual property, when attached with the rights, that establishment of right happens, and then the exploitation of that right happens. So this particular cycle which is there, this cycle, creation and then establishment of right and the exploitation of right, this is what should get created. How this IP establishment of IP right is happening, this IP creation is happening at one place. This IP creation is happening at a person's place. Means if someone is there who is creating this information, the creation is happening there. Then establishment of right is happening after the that right is filed, this IP application is filed. Then it is there are certain criteria for which the IP rights are given. So it is evaluated by that administering body, and that is where the IP administration in India, there are certain laws, and then there are certain bodies which have got created to administer those laws. And for the sake of discussion, which we are having right now, is the patents that we'll be talking about. Of course, there are trademarks, copyrights, geographical indication, design, semiconductor. I think most of you may be knowing the basics of IP, so I'm not going to deal in that. And if someone particularly has any confusion, he or she can ask after this session that what basically IP means. Right now, I'm trying to focus myself on patents. So when we talk about patents, it is with regard to the technological innovations. So when some technological innovation has happened, suppose some startup or MSME is working in its lab and has come up with some good technological innovation, like we can take the example, say, air purifier for the Delhi pollution. Then that person will go through, will conduct a prior art search, means what was available in the market and what was the problem with what was available in the market, and how that problem is technical in nature and how it needs to be solved. When this particular thing is having a concrete shape, then an application is filed in the patent office, and patent office has got a particular, you can say, procedure to deal with that. And then the examination happens, and after the examination and thorough scrutiny of that application, a monopoly right is given, which is called patent, which is for 20 years. Now this, from IP, you have graduated to IPR, which has got established on your name, right? Our right has got attached to you. So it means that this particular patent belongs to you on this particular technology for next 20 years. And for next 20 years, you are going to exclude others if they use your technology or sell your technology or commercialize your technology without your permission. So this particular aspect that you get is leading to economic growth to your organization, as well as then finally adds up to the GDP of the country. So whenever we come up with the IP, 5 more minutes. I suppose that it was for till 4 p.m. So let me rush through later. Okay, so this is how the application filing happens. You file an application, publication happens, then you file request for examination. On the basis of that, the examination happens, and then if you meet all the requirements, and requirements are that whatever invention you are filing, it should be new, it should be inventive, and it should have capability of commercial exploitation. So when your invention meets these criteria, then patent is granted, otherwise it is rejected. The process is that there are certain formal requirements that, okay, it should be filed within certain timelines, and then certain fee should be filed. And then the technical examination that I am talking about, the novelty assessment of the novelty, inventive step, and the industrial capability is done. So once that criteria meets, then it is granted. If it doesn't meet, then a hearing is offered, which happens with the controller, and based on the hearing, controller decides whether this particular application should be rejected or it should be granted a patent. What are different things in the patent law which can be utilized, and the different IPR strategies that startups and MSMEs may benefit with? First thing is fee reduction. Startups and MSMEs has been put by the government at the equal pedestal as the individual inventor. In Patent Act, individual inventor, fees for the individual inventor and for the, say, other than natural person, the MNCs, they have got different fee structures. So for the startups and MSMEs, there is a significant fee reduction, which is, so I must use the word SMEs for the small, for the MSEs, for the micro and small entities and startups. The fees is equal to what it is for the individuals. So this is a huge benefit. So first thing that can be utilized is fee reduction part. Second thing that can be utilized is that earlier there was no provision of expedited examination. However, since 2016, a provision of expedited examination has been made. But there were only two criteria, and first one was that the India should be selected as ISA or IPA, and the second was startup. However, the same has been expanded, and now it is for small entities also. So small entities or startups, they can file for expedited examination. So expedited examination, generally what happens that in patenting, there is certain backlog of say 4 to 5 years. So normally it takes around say 6 7 years to get a patent. However, when you come by expedited route, it gets examined very fast. Majority of the expedited applications get granted or refused within 1 year. So expedited examination route is one of the biggest benefits that startups and MSMEs can get. And this particular thing was brought with the idea that since startups and MSEs, they work in those areas where the you can say the gestational period for the technology is relatively low. So that is why the expedited examination is there. The next strategy that can be utilized, the next IPR strategy that can be utilized is utilizing the facilitator schemes like SIPP scheme of DPIIT or IP Mitra scheme. When you utilize this type of schemes, then you can recover a lot of cost and you can file a lot. You can file a lot of IP applications with the help of facilitators. One more strategy that can be utilized is if your organization is not synced well with regard to the IPR and they have not come on pedestal with regard to filing lots of IPs. So you can organize a lot of awareness programs or join various awareness programs that is conducted by government bodies as well as commercial bodies. So when you bring awareness to the organization, when startups and SMEs can bring awareness to their organizational setup, then the mindset itself gets tuned to the IPR thing. Then the mindset becomes that okay, whenever we are coming up with some new product or process, we need to file for say patents. And this is where startups and MSMEs can change the game rule of the game, because once you have IP valuation, and incidentally 2018 was one of the watershed moment in the history of IP. In fact, the world economy, because that was the time when the whole the valuation of the intangible aspects valued more than the tangible aspects. I'm talking about the world GDP, valuation of world GDP. So if you'll see for the past 5 6 years, we are in an era where the intangible aspects value more than the tangible aspects. And incidentally, when Facebook acquired WhatsApp, that was the thing. And a company of 150 people was acquired for around 19 plus billion dollars. So this is the importance of IPR. And IPR cannot be, IP strategy cannot be percolated just by the owner of a startup or the CEO of the startup or SME, but it is something which should be imbibed in the culture, which should be part of the thinking of the people. And this can only be brought through various awareness programs, utilizing various benefits that is available and filing. It's just like that more and more you do, it's just like swimming. That more you swim, better you become a swimmer. Similarly, with regard to the IPs, more you file, better you become with the IPRs. You cannot feel that first you'll become a very professional filer and then only you can start filing. You file it, have a taste of the whole process, and then you understand that okay, I should move ahead. This is one of the example that I would show. This was on my own case. This particular application I granted within 7 months, which is generally doesn't happen. But since they utilize the provision of Rule 24C, which is for the expedited examination, this particular application was filed in Feb 21, published on in Feb 21 itself. Then request for examination, expedited examination was filed. FER issued, and then hearing conducted, and date of it was granted in September 21. So this is the kind of impact that these various schemes and the IPR strategies that can be utilized, and this just imagine this particular startup organization can then the bargaining power of that startup will enhance multifold because that person has got or that organization has got uh, patent with regard to particular technology. So it helps, it really helps. And one more thing is that when we have this filing of the patent application, you can file on the website. So there are certain basic things which is required, and I'll just utilize 2 minutes more.
Sure, Santoshi.
Yeah, and this is with regard to this particular aspect. That when we talk about the techno-legal documents, when we talk about the patents, it is a techno-legal document. Why I'm talking this? Because many a time people fail to understand this aspect that it is a techno-legal document. So when you explain the technology, that's the technical part. When you draft the claim, that is the legal part. Because tomorrow, if someone infringes that technology, you should be able to sue that person. So claims should be drafted with utmost seriousness and utmost clarity. And invention should be described fully and particularly. This is very important. Sometimes what happens that people file the applications in lot of cases, and in the process they forget to protect what was meant to be protected properly. And of course, it should have that title, field of invention, what was the problem that was existing, and how you are solving that. And after you go and explain that detailed description, drawing, abstract, best method, and then you define the what are my claims, what I claim, because claims are important with regard to legalities. So I try to rush through a lot of things, but if anyone has question, they can ask. And thanks a lot.
Sure. Thank you so much, Santoshi. And by the way, I can attest to like some other observations that we have seen from startups that have been filing patents. So firstly, they have to be registered at DPIIT, and if they indicate, if they include that, like we have seen one of our startups get their patent granted in like 7 months' time. And what this does is, apart from just increasing the grant time, like see, no one can predict whether you'll get a grant or not. But at the very least, you know that in a short period of time, a startup is getting an examination report. And what this does is, most of at least the high tech startups in India, the market for them is many countries. So they want to enter PCT. The value of getting this fast examination is that they can make a better informed decision of whether to use PCT or not, which countries to take that additional expense in. And in the best case, if they have a grant, then they go with more confidence. So truly kudos to the SIPP scheme.
Yeah.
So if you don't mind, we can. I'd like to invite Pragati to share her remarks, and then maybe we can take some questions at the end.
Sure. That would be good.
Great. Thank you so much. So
Sure.
let me now invite Ms. Pragati Agarwal. She is a registered Indian patent agent with the Indian Patent Office and has been awarded with the international status of Registered Technology Transfer Professional. This is the RTTP affiliation given by the Alliance of Tech Transfer Professionals. She is currently working as a project manager with ITTO. This is the Innovation Technology Transfer Office at IIT Delhi with a key focus on IP management, tech transfer, and capacity building. She started as an intern at Innovation Protection Unit of CSIR, and later on, she has been actively contributing towards the innovation ecosystem and Atmanirbhar Bharat. As a part of the team, she performs patentability assessments, patent evaluation, FTO, due diligence, technology analysis, licensing, tech transfer, IP and strategy formulation, and she helps protect, manage, and translate innovations in different domains of sciences. And from an academic perspective, she's a biochemist and a DST Inspire Fellowship awardee. Pragati, thank you so much for joining us here today. We look forward to hearing from you.
Thank you so much. Thank you for the kind introduction. So I'll be sharing my presentation. Like it would be helpful if you can confirm it's visible.
Sure.
I hope it's visible.
Yes. Can you go and yeah, full screen mode works well.
So it's moving as well, right?
Yes.
All right. So a very good evening to one and all present here. So I'll be quickly discussing about how to strategize the IP. Like we just heard from Santosh sir, what are the different forms of IP and how to go about the patents, the assessments, and then the filing. So let's also understand the very basic startups. So the startups, the MSMEs, firstly need to strategize their IP, like how to protect, or even start with identifying their IPs. So, for example, any startup is working towards a medical device. For example, I am a startup and I have developed a medical device. So now I have to list all the IPs, all the possible IPs that a single product or a single concept can generate. So when we talk about such multiple IP generation, so they actually add multiple protection to our the concept and help us build the IP towards like around the product or concept that we are working. Well, as I mentioned, the medical device. So, the technology on which the medical device is working would go under the protection for patent application. And the if it is uniquely designed, then that particular design can go under the Industrial Design Act. Other than this, if I am selling it under a unique name or a unique logo, if I have designed some logo for it, so that could be taken under the trademarking. Other than this, usually such devices, even the electronic devices, are always accompanied with user manuals or user guides. So such booklets are covered under the copyrights. That's how a single product can have multiple IPs over it. So it is always advisable to list all of your intangible assets, then embrace it with the multi-layer protection, so that you whenever you are pitching for any investment or any fundings, you are offering a bouquet of IP along with the your idea. So that's the foremost thing that one needs to develop. Other than this, the second thing that needs to be prioritized it when we talk about startups or MSME, the first thing that is taken into consideration is the budget, because currently I am handling like a bunch of startups. Their main focus is to reduce the budgets, to reduce the financials whenever they're talking about filing the IP. So if you are startup IP by Dr. Hemang in the introduction part, so you can always take that into account. Other than that, there are that go on throughout the year, and mostly fundings and grants allocate a portion of their budget to the IP. So you can always use it to your advantage. Other than this, you should always, check for the relevant markets that you wish your product to get it commercialized. So, for example, I have a application filed in India, but I wish to exercise and enforce my rights in USA, or say my products find commercialization or have better commercialization prospects in USA or in Japan. So I need to file an application in there only, because it would be of no use if I am filing an application in multiple countries, though my relevant markets are very few. So try locating the relevant markets for your product, and accordingly you can strategize in which countries you should go and file your applications, and accordingly you can exercise and enforce your IP rights there. Then the third thing that you can do while planning to which IP to file first. So for example, when we talk about patents or industrial design, so both these forms of IP involve novelty thumb rule, that is no disclosure rule. So before disclosing or before going into the commercialization or the marketing or even the advertising, you should first plan to go for an application filing first. While if we talk about the trademark part, so even if some logo or some tagline is already in use by your startup, so you can still go and file an application for it, because trademark does not follow the thumb rule of novelty. But in such a case, in case, for example, you are using some of your logo since 2020, since March 2020, so you need to, and you are claiming that use since March 2020, so you need to present some evidence while filing an application today. So just be prepared with or keep handy such invoices which are raised to the third parties as an evidence proof, which shows that yes, you are using these logos or taglines since the time you have you are claiming. So you can plan it that way. In case it is a technology, in case it is a product or a process, you must file an application before disclosing. In case it is a unique design, so you must file an application before disclosures. And other than that, trademarks can anyways protected, can anyways file application, because they do not require a novelty rule. Now, as a keen observer to the startups ecosystem, so the ownership is actually very disputable subject matter. So what happens? So in some cases, even the founders own the IP, and that IP on which they have built their startup. So in such cases, or even the co-founders who own the IP, it is recommended to have that IP in the name of your startup. It brings a legal and financial, like it uplifts your startup in terms of legality and finances. And of course, if you're thing an IP, then you can pitch your deck to the investors saying your startups have something solid in its name, right? Because in case a founder is having an ownership to the IP on which startup is working, then it would be of least interest to an investor or any any funding agency. Like, why would they invest into something which doesn't have any monetary value, or if it is not leading to any kind of monopoly in the market? So in such cases, in cases of startups, it is always recommended to register all the IPs in the name of your startup. The like how you can select, there are to be filed while filing a patent application. So first is the applicant. So applicant generally owns an IP. Other than that, there comes the inventor's part. So, very wide to that invention. Like, not everyone can be an
Your
inventor.
voice is breaking in between. Sorry to interrupt. Your voice is breaking in between.
Maybe, ma'am, can you please close to the audio?
Is it better now?
You go ahead, ma'am. It's better. Now you can proceed.
Okay. So the next tip is like how to select the inventor. So not everyone can be the inventor to the invention. So decide on the basis of their contribution. So whoever has substantially contributed to the invention or the concept that is being developed, include those inventors and not everyone in your team, because even having them having unnecessary inventors in the list will double up your work while going for a commercializations. Now, the important thing that needs to be taken care of with respect to your IP while hiring any new employee or while offering internships, just be prepared with the employment contracts and have the IP clauses in place. And this has now become a very common practice, because at times what happens, people innovate or people generate IPs out of their employment period and they register it in their name. So what happens eventually, your startup will not be having any stake onto it. So for example, I am presenting this presentation, so I have prepared this during my employment period, right? So the copyrights is definitely owned by my organization, which is ITTU. So write such clauses in the employment agreements, letters you are offering. This will help you well. Now, if we talk about like how to go about the licensing agreements or the IP transfers, so for this, let's understand it through a way. For example, I have developed something, but I need a manufacturing partner, or I have developed something. I need it to be I need to get it tested from a third party, or I need to get clinical trials done. So for that also, you need to have proper agreements in place. You can have CTAs, clinical trial agreements. You can have license agreements if you are giving it for the manufacturing, and those agreements, will specify the minimum duration and the minimum and the maximum duration that the license can be held accountable. Other than this, who can use the IP, how can you use the IP, and by what extent use the IP, and in which circumstance breaching the confidentiality as well. So an year back, I give you an example. An year back, what happened? A startup vendor, so the manufacturing vendor took all the details. Of course, if you are giving someone to manufacture your product, you need to share some sensitive information with them. Even in some cases, you need to share the know-hows with them, so that a good quality product can be manufactured. So that startup did all the discussions with with their vendors, and the moment, like the day they exchanged all the information with them, a day or after a day, the vendor said that they cannot do it, and like they just stepped back. The startup had promised someone to show their product. So in that case, the startup to show them the NDA, agree to show or to ask the manufacturing sensitive with respect to that particular product, but startup was unaware of such things. They had not no contracts, nothing, no NDAs were done with the manufacturing vendor. Though it didn't cost them was a very risky situation then, and they and in because they were not get the product manufactured and to the their investing agency. Email.
Pragati, can I give you a time check for? Can you take maybe 2 minutes and wrap up, please?
All right, all right. I guess. Yeah. So
Perfect. Good time.
yes, I was just mentioning. So these agreements, they may appear like very your concept and your idea is the only thing is it's your baby, like your startup is your baby, and then you have to take precautions, you have to take all the, like you have to secure all the four corners before moving ahead or before disclosing it to anyone. So by following these steps, you can secure your IPs in a well protected manner. That was all. Thank you so much.
Sure. Thank you so much, Pragati, for sharing such wonderful insights. And I fully agree. And I'm sure our listeners can appreciate that, filing IP and, well, firstly, you have many IP rights to consider, and you have to plan things out. And the nature of this product is such that, it's not like you can say, I'll do it next year, and then things will happen. We've seen startups that have gone and spoken in public forums, and thinking that, oh, we'll file our patents next year and all that, not realizing the risk that they've brought up to themselves. So I really thank again our wonderful speakers here, Santosh ji, as well as Pragati ji, for sharing such wonderful insights. We have 2-3 questions in the chat box. So probably the first one is by Professor Pratik Oak, which is, in India, how to patent any software-based idea. Santosh ji, this is right up your alley.
Yeah, yeah, thank you. When you talk about software ideas, first thing is that ideas don't get patented. Only when that idea you have worked with and find out that, okay, there is some feasibility study and this particular idea can be implemented. Because apart from novelty and inventiveness, there is the third criteria, which is capable of industrial exploitation or industrial applicability. That capability need to be checked. So first thing, that it should be more than an idea. So second thing is, then when you say that what your question should have been, it should have been how to patent any software based invention, not idea. So when you talk about software based inventions, what is important is the technical effect, whether it is leading to some technical effect or it is just leading to certain cognitive effect or incidental effect. That is something which we look very categorically. So you can get a software-led invention, you can get patent over that in India, but what is important is that that invention, whether it is leading to some technical effect or technical contribution, and it should not be merely something which is leading to a cognitive effect. What I mean to say, let me just elaborate it a little. Say some information is being displayed in tabulated form, and later on someone comes up with an invention which says that instead of tabulated form, we'll be displaying this information in, say, pie chart. And then you say that the decision making becomes faster when someone who is looking at this perceives it better in terms of pie chart instead of a tabulated form information. So you may say that it is a technical effect, but for that invention, for the patent office, it is not a technical effect. It is just a cognitive effect which that person is looking into that. At the same time, if you say that if something was getting processed by, say, 10 steps, now my invention, though it is based in software, and it is making it faster, that instead of 10 steps, it is getting solved through 4 steps, and it is leading to saving of the bandwidth and the resources, then this will be called a technical effect. So when you say software-led inventions, the main aspect is whether it is leading to a technical effect or technical contribution.
Great. Thank you so much, Santoshi. And you also, I think, answered a related question by someone else who wants to get a patent for their algo trading platform.
Yes.
So I think what you
yes.
said really applies towards that question also.
Yeah.
I'll bring up the next question, and this is probably for Pragati, which is, and I'll give you two questions at the same time, which is one, how to check the market value of patented inventions, and broadly, what are the steps for tech transfer?
All right. Shall I answer?
Yes, please.
Okay. So regarding the assessments of the market, so depending upon like it completely depends upon like how the competitive products are there and how your technology is overlapping with them in case any features are getting overlapped with them. So first method is this, that you can check it directly by comparing your product over the available products in the market. Other than this, there are several databases that of course can help you with the detailed market assessments. So in such like such databases help you get a predictability of how your product or the market of your product would be in the coming years, or down the 5 years line, or down the 7 years line. So you can go for market assessments in that ways. And if we talk about the tech transfer, so so every technology has a getting transferred. So when we talk about the licensing, so the tech transfers generally involve either getting a technology licensed out. So on that we can define our strategies. So the basic steps that are actually common with respect to any tech transfers are firstly the assessments, the tech assessments. So the tech assessments will give you a fair idea on how your technology will be evaluated and valued when you are into the negotiations. Secondly, it will help you scout for the next step after the assessment would be the scouting. So during the scouting phase, you can check the relevant industry partners, and you can outreach through different platforms. Through LinkedIn, you can showcase your in this. You can outreach them in certain conferences or the technology showcases. You can exhibit your product. So the next step is the scouting. The step that will be followed is, in case you have received any expression of interest, if you have received any expression of interest towards the technology, so from then the negotiation starts. So the first thumb rule would be, do not disclose everything in the first meeting. You can always go disclosing the minimum in the first, and then signing non-disclosure agreements with the interested party, and then go into a detailed discussion. But even in the detailed discussion, keep the know-hows with you, because there have been many instances where the industry fetches the information from the innovators, and since they have an elaborative R&D practices, so there have been instances where reverse engineering things have been done. And so just be cautious whenever you are sharing any sensitive information with them.
Great. Thanks so much, Pragati, for the very comprehensive answer. We'll take one more question, and this is by Dr. Navya. Now, this has partially been answered in the chat box, but Santoshi, this is for you. I'll just summarize the question, that they want to patent a product which has two components, but in the market, there is already a three-component combination patent which has been granted. Now this new, I guess, 2-component product is performing very well at the field level. So firstly, is patentability possible? And second is, how is this going to infringe the prior 3 combination product patent? Now, someone has already answered that the product efficacy should be much higher than the 3 product combination. So that is the route to get a patent. But I guess the question that Dr. Navya is asking is that
no, it's not like that. Yeah, no, it's slightly different. When we talk about the product efficacy, that takes it in some other direction. First thing is that when you are having in the market a 3-component product and you are bringing a 2-component product, that 3-component product is a very specific prior art. When you are talking about 2-component product, that is basically a generic thing. So specific prior art can kill the novelty and inventive step of a generic invention. First thing. Second thing, having said that, you can say that if one thing was performed with 3 components and you are able to perform the same thing with 2 components, and this is leading to economic significance, means you are economically you are making it more viable. And second aspect is if it is leading to technical advancement. Now this technical advancement should show it very categorically that how it is better than that 3-component combination. So that is possible, you can get it. However, you'll have to show it that how it is better than the 3-component. And second aspect is that you can also focus on the economic significance part also. At the same time, just as a concluding remark, I would like to add a couple of things which is from Ms. Pragati's presentation. One thing that she talked about was very crucial, and that is that sometimes you can say founder of startups, they have got very emotional attachment with their organization. So when they file patents, they say that the applicant would be me as well as my startup. In the process, they lose the benefit of expedited examination, because expedited examination is available for the startup, not for that individual. And when we say, when the controller says during the hearing that it is not available, they are taken back and they will say that, "Kaise sir, ye kaise possible hai? Ye to mera baby hai." So sometimes I say it in a very cruel fashion that aapka baby tha, now you have, that baby has got delivered, now it is no more your baby. So that thing. And the second thing, and which is very important, and a lot of startups are doing this mistake, is this IPR clause in the employment agreement. What happens that startups hire people who are very quick to move out. They attain certain skills and they move out. By the time prosecution of your application happens, that person has left the organization. And in the process, you are not being able to meet the criteria of Section 6, that who can file a patent. Patent can be filed by the inventor or assignee of the inventor. From where you will get the assignee of the inventor thing, either you should get it signed at the early stage itself, or second thing, that you should have that IPR clause in the employment contract, so that if that employee is not traceable on the later date, you can show that during the concurrency of the employment, we were having the rights. So these are 2 things on Pragati presentation.
Great. Thank you so much. We are, we've had a wonderful discussion this afternoon, and despite going, say, roughly 10 minutes over time, happy to share that our attendee, count has hovered nearly the same. We had almost 100 attendees. Even right now, we have 82 plus attendees. And I don't know how many webinars you all have been at recently, but we all face this concept of webinar overload. So I first and foremost applaud every patient listener. We had just so many professors that have tuned in, who are so curious to learn about IPR. So kudos to you, looking forward to your inventions. And once again, thank you to our wonderful speakers, Santosh Kumarji, as well as Pragati, for their wonderful remarks, as well as patient answering of questions. And I also want to thank the ASSOCHAM team for their fabulous organizing and getting all of us together. So let's conclude the program here, and we look forward to the next one. Thank you all.
Thank you. Thank you, everyone.
Thank you, everyone.